Various groups, as well as opposition parties, are taking joint legal action, as we've been reporting for several weeks now, against Eskom and two government departments over the ongoing electricity crisis. ActionSA, the IFP and UDM are among those seeking interim relief from years of load shedding in papers filed in the High Court in Pretoria. The 19 applicants are demanding that Eskom and the Public Enterprises Department produce a plan within 7 days showing how electricity supply won't be further reduced. They're also looking to force government to release documents relating to the construction and performance of several power plants. ActionSA says the relief being sought is for all South Africans, but hospitals and schools in particular. Let's talk more about this now. We're joined by ActionSA's Head of Strategic Litigation, Advocate Gillian Benson. A very good evening to you, Advocate. Good to have you on News at Prime. First things first, why is the court route the best way to do this?
Well, we've considered every other option, and I think every other PIA application that has been served on Eskom and all the other stakeholders has come to naught. If we don't now approach the courts and ask them for their intervention, we don't see anything happening for the foreseeable future.
And sum up then the arguments which you've made in your court papers, which you're putting before the High Court, why you think that Eskom should be held accountable by a court.
Well, the Energy Regulation Act, specifically Section 2 of the Act, read with Section 21, without getting into the exceptionally complicated papers that are before the court at present, provides that the energy provider, Eskom, is obligated to provide us with uninterrupted electricity. The Constitution further backs that up in Section 7. So the Eskom and the government are failing us wholly in this regard, and so we need a court to intervene. Unfortunately, that seems to be the case with many provisions of government services at present.
And if Eskom says, well, we're doing our best to provide uninterrupted power supply to all people 24/7, but we're working with aging infrastructure that fails at an unpredictable level, so therefore it's a situation beyond the hands of management, how would you respond?
Well, the problem with that is that is what they keep telling us, but they don't show us. Whether it was under the leadership of Durate or otherwise, we keep being told this, but we're not being informed on a daily basis. We're told there's sabotage, we're told that there's broken infrastructure, but now we want you to show the court exactly what you rely on, what that evidence is. We're asking them to produce that to the court, and then we want them to come up with a plan to the court's satisfaction. That's going to now ensure that the problem is going to start improving instead of deteriorating as it has been.
But Eskom has, in the last few months, especially with the worsening load shedding situation, been giving these technical briefings, basically explaining with graphs and charts where things are, where we need to get, and what the problems appear to be. We've also seen statements issued around the arrest of people who are alleged to have been involved in some of the sabotage at the utility. Why is that not enough?
Well, it's not enough because it's not improving anything. And the graphs are unreliable. We want to know what the source of the information is. And we want to see, for instance, we want to know what agreements are being entered into for alternate electricity supply. Which private entities are they discussing alternatives electricity supply with? Giving us graphs from in-house are unreliable. We're not satisfied. And we need the court to now regulate how the plan is going to be implemented long-term, and that's the long-term relief we seek, not the immediate relief we seek, so that it can be properly monitored and that all of the parties that have been asking for this information now be furnished it so that we can make our own analysis, an independent study, and so that we know whether the information they're feeding us can be verified.
You also want what you say is reasonable notice of load shedding. What would you consider as reasonable notice? Because whenever it does happen, especially with the escalation in the stages, we're told, well, these are systems that have just broken down and therefore the response has to kick in almost instantly.
Well, amongst the lawyers, of course, there's much debate. There are 19 applicants. There is much debate as what is reasonable. But I think that, to my mind, reasonable would be to wake up in the morning and not find myself from the promised Schedule 2 and 3 that we were given, and suddenly you're in stage 8 or 6. We'd like to know beforehand so that parents can plan ahead with their children, that families can cook on time or know that they're not going to be able to. So whether it's a couple of hours or a couple of days, that's debatable, and we will flesh that out and see what Eskom tells us that they can't do when they file their answering papers in a few weeks. But I think that what's reasonable to one is not reasonable to another. The hospitals need to know when they're not going to have power so that they can switch incubators and oxygen tanks on to generators timeously.
But
doing it within minutes is not assisting us at this stage.
There have been exemptions granted to some public health facilities. I know it's not all of them. That happened towards the last quarter of last year. In some provinces, people are saying more needs to happen. On that score, how would you convince the court that the distance travelled in the exemption or the granting of the exemptions has not been far enough, especially to protect the lives of patients and indeed make sure that medical professionals aren't having to sort of rush at the last moment and make alternative arrangements?
Well, we're hearing from some of the applicants who are medical practitioners in the field that although they were supposedly meant to be granted such exemption, it hasn't happened. Some of the major national hospitals, public hospitals, are having to run generators. Now, obviously, in the rural areas, to grant certain exemptions, where is life, the right to life, fair in the metros or also in rural areas? So this application caters for all of those people. There is debate amongst Eskom as to whether the exemption to certain facilities is even possible. But we haven't seen a blanket exemption granted to all public facilities, and it's causing chaos in the hospitals. Whether it's theatres,
pardon me, where's the difference among yourselves about where exemptions may not be possible?
Sorry, amongst us as the lawyers, or
overall at this point,
us and Eskom?
Between yourselves, Eskom, and as the various teams.
We are asking as the various teams that all clinics and hospitals that are supplied electricity by Eskom be exempted from load shedding. We believe that that is possible from the expert evidence that we have obtained. The Eskom is arguing that it's not always possible. And we want them to come and show us why that is. And because they've based on that argument themselves.
Right. And in terms of the level of consultation that's gone into crafting your legal arguments, how much have you leaned into the knowledge of technical experts who are able to speak on power generation, what should and should not be happening, and what is reasonable especially?
Those consultations have been ongoing. The difficulty that our own experts have is that we are not privy to the documentation that Eskom relies upon to refuse to do these exemptions for certain areas. So that is why in the first part of the relief sought, before we go to part B, which is now how we're going to solve this permanently, we're asking for that documentation so that our experts are, again, the engineers, are able to look at it and tell us what can and can't be done and whether what they're telling us can be verified. Because right now we feel, I think the legal fraternity at large and all of the applicants feel that we're being fed tidbits of information but insufficient detail.
From the disclosures you're seeking then, Advocate Benson, how much of what you now need to know or want to know should have been available through the parliamentary processes, because there's oversight at that level, and Eskom, like any other state-owned entity, and the ministries are involved basically in dealing with energy issues in this country, have to appear and account. Why has that not been sufficient as a process to basically perform oversight?
Well, we're not in Parliament as ActionSA, but we'd love to know that too. Why has parliamentary oversight not obtained sufficient information? It seems that they don't seem to succeed in obtaining information that is required, again, not just on this matter, but in various issues facing South Africa. And it's really sad that the last bastion of hope is for us to run to the High Court and ask for our judiciary to assist, because parliamentary oversight seems to be failing us, especially in relation to Eskom.
Advocate Gillian, Benson, good to speak to you.